As we might recall, Channel News Asia ran a documentary series, Don't Call Us Poor, which explored challenges that low-income families in Singapore face in getting aid. It attracted much attention, particularly the episode where a woman talking about applying for a personal protection order against her husband. She said she could not get the order because he disputed her claims that he was violent towards her. She's not alone. Over the past 3 years, the Family Justice Courts received an average of 3,200 applications a year. But the number of such orders is being issued in the same period, average 1,200. That's fewer than half the applications. In today's Spotlight, Alice Shah looks at the challenges some applicants face in getting the order, as well as reasons why fewer orders were issued.
For years, Mei Hui lived in fear. The 39-year-old was terrified she would be killed by her husband. The beatings eventually took their toll.
I woke up one day and realized I didn't want to be a victim anymore, and that I wasn't created for this kind of life. But the real decision maker for me was when I realized that his rage was so out of control that he didn't even see the children were also getting physically hurt when he was hitting me.
She decided to apply for a personal protection order which aims to stop the perpetrator from using violence against his family. Those who breach the order could be fined $2,000 and jailed for 6 months. To get a personal protection order, the victim first makes an application at the Family Justice Courts or at any of the 3 family violence specialist centres. A summons will be issued for the alleged abuser to attend court, usually within 1 to 2 weeks. A temporary personal protection order may be granted if the district judge thinks the victim is in immediate danger. In court, the alleged abuser must admit to using violence and consent to the issue of a personal protection order before it is granted on the same day. If there is no admission or consent, both parties will go to trial, which could turn out to be a long, drawn-out process. Mei Hui couldn't understand why she had to go through the process.
I don't know why his opinion was sought. I had all the proof and all the evidence, and I felt like I was on trial. Like nobody believed what I was saying, and I had to prove that what I was saying was true. When actually I think the person who's wrong should prove his innocence. Why did I have to prove that I was abused by him?
For Mei Hui, her husband did admit to using violence and consented to the issue of the order. The process eventually took about 1 month.
The process could involve making the woman feel less victimized, because they're already a victim, and then you make them stand there and prove that they were victimized. I think the onus of proof should shift to the abuser.
But a lawyer thinks both sides should have their say.
Some victims feel that this is a long process, they want an immediate order, but I think that would go against the grain of justice, because if you just hear one side and make a final order, then that's not fair to the other party.
Mr. Amulat said that in the meantime, the victim can still get protection with the expedited order. But Mei Hui has another concern, the duration of the process.
It was actually quite a long process. It took longer than I thought it would. I think the number of times we have to go back to family courts could be lessened.
A social worker said the process could sometimes drag on for even up to a year. That's because it may be difficult for victims of abuse to produce the necessary evidence.
It can be very stressful for the client to actually be having to explain, what kind of abuse they have been through. Yeah, especially because a lot of times there could not be concrete evidence in terms of some of them they might not have gone to see a doctor after they are physically hurt, or sometimes in cases of psychological abuse, there might be no so-called evidence.
Another lawyer said one consideration might be to make the application of the personal protection order an administrative matter instead of a judicial one. This may mean the case is heard by a specialized tribunal instead of a judge.
Depending on how contentious things get, if decisions come out from that appear to be unfair, then that may end up before the courts as well for breach of natural justice and so on. So that may just add to the process rather than make it shorter. But there are different ways of looking at it. But at the moment, I think the time lag bit is probably a necessary evil to give both sides a chance to be heard.
According to the Family Justice Courts, there were 3,141 applications last year. But the number of orders issued was 1,199, less than half of the applications. Similarly, in 2013 and 2012, the number of orders issued was fewer than half the applications. The court said this is because not all applicants are victims of family violence in need of protection. Many of these cases were disputes over inheritance or custody battles, and some of the applications were withdrawn as the parties were able to resolve their issues before a trial date was set. To help those who are in need of protection, a social worker feels there should be greater awareness.
I think the main thing is the awareness of their rights. Suppose if we can do something like a video, of working through with them to explain about the process of applying for this PPO application, so that might actually mentally prepare them. The other option could be a legal friend, should be like a court friend who can accompany the client to go for the court mention, as in the case where they actually feel very fearful.
TransSafe also helps its clients by counseling them and going through with them the court processes so they are emotionally prepared. The centre hopes more can be done for the victims of family violence so they can have a less stressful experience in their application process.